David Crispin with the United States Marine Corps.
Jacqueline Beam, 519th Military Intelligence, U.S. Army.
Matthew Hernandez, United States Navy.
Keith Claxton, United States Navy.
Paul Portillo, United States Navy.
Robert Griego, U.S. Navy, Operations Specialist.
Chris Oakley, United States Navy, United States Marine Corps, State of New Mexico Army National Guard.
Melinda Medlin, United States Army.
Norman Aragod, U.S. Army National Guard.
Raven Nieto, United States Army.
Oscar Martin Lopez, United States Marine Corps.
Martin, United States Army, retired.
Valentino Baca, United States Marine Corps.
Jeff Folgate, United States Air Force.
Kenneth Quintana, United States Army, and as well as New Mexico National Guard. Combined service, 24 years.
Santa Fe County is hiring. Every Tuesday, Public Works holds a rapid hire event at 102 Grant Avenue at 8:30 a.m. Also, the Correctional Facility holds a rapid hire event every Tuesday at 9 a.m. That is at 28 Camino Justicia. We have great jobs, great pay, and great benefits. Come work with us. Why do you work for Santa Fe County?
For my family.
For your safety.
For you.
For my community.
For the public.
For the community.
For the retirement.
To serve my community.
For my family.
For the outdoors.
David Crispin with the United States Marine Corps.
Jacqueline Beam, 519th Military Intelligence, U.S. Army.
Matthew Hernandez, United States Navy.
Keith Claxton, United States Navy.
Paul Portillo, United States Navy.
Robert Griego, U.S. Navy, Operations Specialist.
Chris Oakley, United States Navy, United States Marine Corps, State of New Mexico Army National Guard.
Melinda Medlin, United States Army.
Norman Aragod, U.S. Army National Guard.
Raven Nieto, United States Army.
Oscar Martin Lopez, United States Marine Corps.
Martin, United States Army, retired.
Valentino Baca, United States Marine Corps.
Jeff Folgate, United States Air Force.
Kenneth Quintana, United States Army, and as well as New Mexico National Guard. Combined service, 24 years.
Santa Fe County is hiring. Every Tuesday, Public Works holds a rapid hire event at 102 Grant Avenue at 8:30 a.m. Also, the Correctional Facility holds a rapid hire event every Tuesday at 9 a.m. That is at 28 Camino Justicia. We have great jobs, great pay, and great benefits. Come work with us. Why do you work for Santa Fe County?
For my family.
For your safety.
For you.
For my community.
For the public.
For the community.
For the retirement.
To serve my community.
For my family.
For the outdoors.
David Crispin with the United States Marine Corps.
Jacqueline Beam, 519th Military Intelligence, U.S. Army.
Matthew Hernandez, United States Navy.
Keith Claxton, United States Navy.
Paul Portillo, United States Navy.
Robert Griego, U.S. Navy, Operations Specialist.
Chris Oakley, United States.
Agenda.
Hearing Officer Hebert, there are no amendments other than as stated in the agenda. Item D, the Soleil Conceptual Plan Amendment Preliminary Plat has been tabled for this meeting and will be heard in September.
Thank you, Mr. Larrañaga. This time I would call the first case, which is case number 235131, Michelle Jordan variance. Ms. Gonzalez.
Yes, I do. Thank you, Hearing Officer Hebert. Jessica Gonzalez, Development Review Specialist. Michelle Jordan, applicant, requests approval of a density variance to allow 2 dwelling units on a 6.4 acre parcel. Currently, the applicant has an existing main residence and a guest home. The subject property lies within the residential fringe zoning district, where the base density is 1 dwelling per 5 acres. The property is located at 12 North Fork Road within Township 15 North, Range 8 East, Section 25, Commission District 5, SDA 2. The applicant is requesting a variance of Table 8.9, Dimensional Standards for Residential Fringe Zoning, to allow 2 dwellings on a 6.4 acre lot. Residential fringe zoning allows for 1 dwelling per 5 acres. The primary residence consists of 1,353 square feet heated area, and the second dwelling consists of 1,092 square feet heated area, which includes a loft. The dwelling units share a well and are on individual septic systems. The applicant states that she bought the property as is with 2 dwellings on the property. The second dwelling is 2 stories, exceeds the square footage that would allow it to qualify as an accessory dwelling unit and is on an individual septic system, which is contrary to the SLDC standards for an accessory dwelling unit as defined by the SLDC Section 10.4.2.3. The applicant has addressed the variance criteria and staff has responded to the applicant's comments. Building and Development Services staff has reviewed this request for compliance with pertinent SLDC requirements and has found that the facts presented do not support the request for a variance. The use may impact adjacent land uses. Residential fringe zoning allows for 1 dwelling unit per 5 acres. Staff recommends denial of the request for a variance to allow 2 dwelling units on the 6.54 acre parcel. If the hearing officer finds the variance criteria has been met and recommends approval of the variance, staff recommends the following conditions be imposed. Madam Hearing Officer Hebert, may I enter these conditions into the record?
Yes, please.
Thank you. This report and the exhibits listed below are hereby submitted as part of the hearing record. Staff requests the hearing officer memorialize findings of fact and conclusions of law in a written recommended order. The Santa Fe Planning Commission may be holding a public hearing on this matter on September 21st, 2023. Thank you. At this time, I stand for any questions.
Ms. Gonzalez, I have a question about the publication on, I believe it's marked as Exhibit 8. And this is strictly the form of it. Ordinarily, it will be a copy of the actual newspaper publication with an affidavit that it was published. And if you look at your Exhibit 8, it's not that. And I'm just wondering why.
Hearing Officer Aber, I was not able to get it from the actual newspaper, so I printed it from the New Mexican website.
I see. Is there an affidavit of publication or no?
I don't think so. I think that should.
Ms. Gonzalez, what are they going? Is Mr. Persino looking at some other issue?
Hearing Officer Aber, yes, he's
Okay,
making copies of that.
Then I have other questions. I understand that there are two dwellings, and the smaller dwelling, is that the dwelling that's also part of a garage, or the garage is part of the dwelling?
Hearing Officer Aber, I'm not sure if it was ever a garage. You can come in, I think.
Well,
or not yet.
I'll ask the applicant these questions if you don't know. What I was trying to get at is if you could back out the square footage of the garage so that the residents would comply with the accessory dwelling rule. But if it's not a garage, if you don't know, you don't.
Hearing Officer Aber, I'm not sure if it was ever a garage.
Okay. And again, back to the notice, I didn't see any photograph of the posting or any indication of the mailing of the notice. Were those in the file?
Hearing Officer Aber, I believe the applicant emailed it to Jessica. Fortunately, we didn't print it up, but there is, Roger is now making a copy of the legal notice in the Mexican.
All right.
But we will have it in for the record once we get back to the office.
Okay, and would that also include some evidence of the posting and the mailing?
Hearing Officer Aber, yes.
Okay, thank you. Ms. Gonzalez, I think that's all the questions I had. Thank you.
Thank you, Hearing Officer Aber.
Ms. Jordan, Ms. Jordan, are you speaking for your application?
I represent Ms. Jordan in the application.
All right, thank you.
It is. Yes. Maureen, M-A-U-R-E-E-N, Mestas, M-E-S-T-A-S, 2213 Brothers Road, Suite 800, 87505.
And I'm Michelle Jordan, 12 North Fork.
Officer Herbert. I'm here on behalf of the applicant. My name is Maureen Mestis. I'm with Orion West LLC. We are a land use and development specialty firm that does consulting in commercial, residential, and water rights matters in New Mexico. And Ms. Jordan asked for our assistance in presenting this application because there's a number of issues and concerns with the status of the property and being required to do the variance for the additional dwelling. What Ms. Gonzalez stated in her presentation is accurate as to the facts of the property. One issue that we wanted to clarify was the matter of the garage.
Yes.
Where the guest house is situated is within a structure that was originally built by a previous owner as a garage, used as a garage, and then remodeled with a permit to a guest house which existed when Ms. Jordan bought the property in 2013. And by all evidence, both the main house and the garage and casita were subsequently permitted by the county for the remodel and the structures and improvements that were made.
And that was in 2013, is that what you said?
She purchased the property in 2013.
And the remodel had already been done prior to that?
It had been done by the previous owner whom she purchased the property from. And the property owner at that time made all the disclosures to Ms. Jordan and to her real estate broker with regard to permits, plans, designs. We have all the permits, the stamped copies of the plans from the county. Additionally, septic systems were obtained for the main house and for the guest house. And we've provided to the county in our application copies of the septic permits, septic inspections, Office of the State Engineer water rights records, and well records.
And can you confirm that the square footage of the smaller, the renovated garage is 1,092 square feet?
That's an approximate square footage of the overall structure. The casita is within that structure, and we don't have an independent measurement of that unit. We can separate the garage from the casita guest house structure and give a calculation of the square footage.
So it would be smaller than the 1,092?
It would be smaller than the overall garage structure, yes.
And you're probably aware that the accessory dwelling unit would be 50% of the larger structure,
Correct.
which is the 1,300. So
the larger structure, as measured and recorded with the county, is 3,113 square feet. That's the main house.
Well, Ms. Gonzalez's testimony and the information that I had listed that structure, list two structures, one being (1,353 square feet, and the second one being 1,092. So I think there's some misunderstanding here.
There's a discrepancy, and Ms. Jordan doesn't currently have an appraisal or a survey with measurements, accurate measurements.
Do you know where that measurement of the 1,353 square feet, where that came from?
No, I don't. And, my house is 4 bedrooms, 3.5 baths.
Oh, I'll stand here.
The primary residence, according to tax records, is 3,113 square feet, and I have a drawing as well. It's 4 bedrooms, 3.5 baths, and a couple of great areas. It's pretty significant size, so it'd be impossible to be 1,053 square feet. Can I present this to you, the tax records?
Yes, yes, I think we'll need that. There seems to be some fundamental difference between what the information I have, and in looking at the aerial, and I'm just going to ask you this, and I know it's not too good for the court reporter, but I'm looking at Exhibit 2, and on Exhibit 2 is the outline of your property. So your larger residence. Okay, thank you.
Hearing officer, but we believe the discrepancy is possibly in a transposing of the numbers because it's correct. It's not possible for the primary dwelling to be as small as 1,300 square feet. It's over 3,000.
It appears to be a large residence from this
Yes.
aerial photograph. At this time, I'm looking for Ms. Gonzalez. I'd like to ask, but I don't see her. Oh, on the other side. Ms. Gonzalez, is it possible that these figures aren't correct? Because it's fundamental to whether or not the smaller would come in under the ADU.
Hearing Officer Aber, if you look at Exhibit 5, this is where I got my numbers from. However, even if the square footage is okay, the ADU doesn't meet the standards because it has a loft, which is considered a second story, and there's two separate septics for the main dwelling and the ADU.
And I don't recall in the ADU rule anything about a loft. I'll have to go back and look, but is that part of the rule?
Hearing Officer Aber, it would be considered a second story, a two-story?
Yes.
So the ADUs has to be a single story to qualify for the ADU permit.
I see, okay.
Plus, I believe that they have separate septics also. So even the two-story right away puts it out of the ADU criteria, and then it's got to share septics and water and electrical to qualify for ADU.
Even though this one exists and apparently has, from the Environment Department, a permit.
Hearing Officer Aber, yes, correct, and hence going forward for the variance of the density to allow the two dwellings on the property.
Okay. Well, is there anything else that anyone wants to add to this? Yes, Ms. Maestas.
Okay. I think it's important to inform the hearing officer that Ms. Jordan has been pursuing the situation of the status of her property since October of 2022. On April 16th of 2023, she completed, at the advice of county staff, a after-the-fact ATF permit for the garage structure and the contents of the remodel of that structure. She was subsequently advised in our meetings, pre-application meetings, that she should change her application to the dwelling variance because of the existence of the two units. She purchased this property in 2013. She has done nothing to change any footprint, any square footage, add or delete. She didn't add any of the septic systems. She didn't do anything other than just move into the property. And her enjoyment of and use of the property was intended to be her primary residence, and also take advantage of hosting an Airbnb, which she's successfully done for 7 years. And the reason why her property has come to the attention of the county is because the county has decided to enforce and enact an ordinance for short-term rentals. She currently has a temporary short-term rental permit. Her short-term desire is to obtain a permanent permit for short-term rental. Her concern also is has many elements to it. She's concerned about the status of the property and the county's view of the property in terms of the improvements that are on it, what the county's going to require her to do. She'd like a determination on that. We see that staff has recommended a denial, and if the hearing officer decides to find the variance criteria has been met or recommends approval, that she submit an application for after the fact. She is very much willing to do that and go through that process because we already have the complete application from April that she was ready to submit. Also, that the additional dwelling, there will be no additional dwelling units beyond what's already on the property. She's in complete agreement with that. She has no desire whatsoever to add any improvements to the property. Also, she provided in her application for the variance all of her OSE and NMED permits, which are a criteria of the staff. She's very concerned because she's about to lose a significant amount of income that she relies on in her retirement. She's owned this property for 10 years. Reasonable representations were made to her that all of the improvements had been permitted, and we have evidence of that. We'd like to know what would be required to bring this property into compliance with the county, and also if she may go forward to obtain her permanent short-term rental permit. If staff is going to recommend denial, she'd like to follow through with what's required to obtain an approval from the hearing officer.
The scope of my hearing here is the variance request. So you, Ms. Jordan, you'll have to continue dealing with the county as to any of these other issues, however this specific case is resolved.
Okay, and can I say a couple of comments?
Certainly.
Okay. So in the particular area that I am in, my property is, it's very complete. It's been permitted in every possible way except for how the county's tagged me. And in my community that I live in, there's a lot, it's for decades, there's been violations to county code with people doing multiple dwellings without permits and whatever they are influenced to do. There's acreage that's 1 acre where there's a house on 1 acre, and right next to that is another 1.8 acre tract with a mobile home, and it's permitted for 2 mobile homes. Right next to me is a 3.8 acre where it's a single wide mobile home right next. So there's a lot of small acreage, and I posted the notice as required. No one made any comment except to say congratulations on short-term rental, because there's a lot of small businesses within my community too. So I feel like what I'm doing is in flavor with the community, and the community has set precedent for doing whatever they want on their property. And I have always thought that I was in compliance. And this does present a hardship to me if I have to do anything else that would take down a loft or remove a septic system. It's like I'm 70 almost, I'm 69 right now. So it's like, this is hard.
Ms. Jordan, what was your understanding as far as in 2013, what was the zoning density of that property?
You know, I didn't even pay close attention because it was a completed guest house. It was a completed house. The due diligence that I did, I didn't notice that second dwelling was not in compliance. I moved from out of state to New Mexico, so New Mexico is new to me over the last decade. And so, to me, I thought I was always in compliance.
Okay. I would ask the same question of staff. Ms. Gonzalez, Mr. Larrañaga, do you know what under the 1990 code, what the density in that area would have been?
Hearing Officer Hebert, I believe in this area that it was in the basin fringe, so that would have been 12.5 acres, I believe, per dwelling.
In the basin, if it was in the basin fringe.
Yes.
Right. Thank you for your testimony.
Thank you.
Thank you. This time, does staff have anything further to add in relation to these statements?
Hearing Officer Hebert, no, I don't.
Thank you, Ms. Gonzalez. Well, at this time, I will prepare a written recommendation, and that will be within 15 business days. Thank you for your attendance and your testimony.
Hearing Officer Hebert, public hearing.
Oh, I'm sorry. Did anyone here want to make any comment on this application? It's in attendance. Seeing none, I then turn to you because my screen is blank. Is there anybody there?
Hearing Officer Hebert, I see no one wanting to speak on WebEx.
Okay, thank you. With that, that will conclude this case. Thank you very much. The next matter on this agenda is case number 235130, Dominium variance. And if you'll just give me 1 second, all these papers. All right, thank you.
Thank you, Hearing Officer Hebert. Manuel Ryan Olivas, Development Review Specialist Senior with the Growth Management Division. Dominium applicant Caitlin Tweet, agent, requests a variance of Chapter 8.10.3.13, Table 8-38, Dimensional Standards, to allow more than 25% of the building footprint to exceed 36 feet and to exceed the 36 feet max height to 38 feet from finished grade. The applicant also requests variance of Chapter 10.21.2, multifamily housing units, to allow more than 12 units per building. The site is located at 4608 State Highway 14, within the planned district Santa Fe Community College District, within the Employment Center Subdistrict, within Township 16 North, Range 80, Section 24, Commission District 5. The applicant is proposing a 312-unit affordable multifamily apartment complex consisting of 120 two-bedroom units, 132 three-bedroom units, and 64 bedroom units, to be known as Turquoise Trails Apartments. The proposed apartments will consist of 13 three-story walk-up style buildings with a proposed maximum height of 38 feet from finished grade. The applicant is requesting a variance to allow more than 25% of the building footprint to be taller than 36 feet and to exceed 36 feet overall max height to 38 feet from finished grade. The applicant is also requesting a variance to allow more than 12 units per building. The current plan has 24 rental units in each apartment building. The applicant states, our proposed community will house the workforce community that is needed to drive and stimulate economic growth and development within the county. The most cost-effective and maximization of number of homes is via three-story walk-up buildings. The variances are necessary to make the project a reality. The applicant also states the SLDC shall assure that a diversity of housing choices is available to residents within a wide range of economic levels and age groups. The applicant has addressed the variance criteria for both variances, and staff has responded to the applicant comments as contained in the memo. Building and Development Services staff has reviewed this request for compliance with the pertinent SLDC requirements and has found that the requested variances are necessary to accomplish the purposes and intent of the SLDC and the SGMP to create diverse housing for the community. The applicant addressed the variance criteria which supported the granting of the variances for the proposed multifamily development within the county. Staff recommends approval of a variance of Chapter 8.10.3.13, Table 8-38 Dimensional Standards to allow more than 25% of the building footprint to exceed 36 feet and to exceed the 36 feet max height to building. Staff recommends the following condition be imposed. 1, except for variances granted, the application for the multifamily apartments shall meet the requirements set forth in Ordinance 2016-9, the Sustainable Land Development Code. This report and the exhibits listed below are hereby submitted as part of the hearing record. Staff requests the hearing officer memorialize findings of fact and conclusions of law in a written recommended order. The Santa Fe County Planning Commission may hold a public hearing on this matter on September 21st, 2023. Hearing Officer Hebert, I stand for any questions.
Mr. Olivas, I, of course, always go back to the notice, the first thing, and I'm looking at the published notice in the newspaper, and I just think it's borderline deficient, because I think the eye-popping part of this whole process is the fact that it's a 312-unit facility that's being proposed, and yet that's not mentioned anywhere in the notice. This notice could apply to anything. It doesn't even say how many units or whether it's an apartment complex. It could be something as small as just 13 units. It talks about the 12 units per building. And I'm just, I just am noting that, nothing else. I'm not expecting you to address it, but in my mind, I was looking to see something that indicated this was going to be over a 300-unit apartment building. And that's not what I saw. The other couple of issues were, because I did hear the other case 6-7 months ago of another apartment complex in this very same area off of Highway 14. So I am familiar with, you know, some of these things. But is it your understanding that the portrayals in the exhibits that they have provided, it shows the buildings with some offsets? And what is your understanding as far as these buildings? Are they just going to be monolithic blocks, or will they have some kind of offsets and staggered features?
Hearing Officer Aber, I believe the Community College District, this is in the Employment Center of the CCD, have architectural standards that the applicant must meet. Again, these are very preliminary drawings. They have not submitted for the site development plan for this until they get the variances, or see if they get the variances.
I see. Okay. Another question that I may ask the developer, it may say for the developer, and it just goes to the amount of open space. Do you know anything about the details of that?
Hearing Officer Aber, this particular project is subject to 30% open space.
Okay. And Mr. Olivas, there were 2 letters from the developer, and one referenced not only 2-bedroom and 3-bedroom units, but 4-bedroom units. But I believe the most recent letter dropped the 4-bedroom units. Is that your understanding, that these would just be 2-bedroom and 3-bedroom units?
Hearing Officer Aber, again, this is conceptual, and possibly the agent for this project would be able to speak to that.
Right. And there was a note at NBB4 in your work. I'm trying to find it. The staff response that's in the bottom third. Oh. It's on NBB4, and it's the bottom third of that page. And and it's staff response, and you're addressing the visual impact on the surrounding community. Do you see that statement? Staff response, the lay of the land where this affordable housing complex is proposed.
Hearing Officer Aber, yes, this lot drops down from I-25.
Okay.
It will be visible from 14, obviously, but from I-25, it's kind of has a buffer. And there's also I don't remember what the exact footage is, but there is a substantial setback from I-25 from the pavement of I-25.
Well, since we're talking about that, it shows vacant lots on the I-14 on the Highway 14 side. It shows vacant lot, vacant lot, vacant lot. Are those owned, or are those subject to being developed by someone else or by them? That kind of went to my, is this part of the open space? I'm looking for it, I can't find it. I think it's Exhibit 2.
Hearing Officer Aber, are you looking at Exhibit 4, the aerial on this?
Well, I do have it here somewhere. Yes, I have one of those. I do have several aerials. But specifically, there is a proposed site plan, which is a drawing that shows the actual buildings and trees and parking. And then between the development are 3 different parcels that are labeled vacant land, and then you have Highway 14. And I just was wondering if those vacant land parcels were part of the open space.
And I'll say, they will be a certain percentage, but this vacant, not a part of, as it's labeled, are going to be commercial lots, which they will come back and do a land division or subdivision to create those lots.
Okay. Okay, thank you. Well, those were the questions I had, so thank you very much for the presentation.
Thank you, Hearing Officer Aber.
Is there someone here that's going to speak on behalf of this application?
Caitlin Tweet at 9000 East Pima Center Parkway in Scottsdale, Arizona. Thank you, Officer Aber and staff, for reviewing this plan with us and answering all of our questions. I do have a presentation that looks like is pulled up here now. I'd like to address some of your questions you had just brought up first.
I'm trying to see if my screen will come up, if this is. Well, I could just look. Oh, okay. Thank you. Okay, I've got it now. Thank you, Matt.
Perfect. As I mentioned maybe before I hop into the presentation, I jotted some of your questions down so I could address those. You had mentioned open space. We had the same understanding, 30% is required. However, just looking at our site plan, we currently have about 50% open space. I'd also like to clarify the unit mix and the number of 4-bedroom units. We will have 156 2-bedrooms, 120 3-bedrooms, and 36 4-bedrooms. We had mentioned the setbacks from I-25. Our understanding is the required setback is 150 feet. However, we've added an additional 74 feet. So our closest building is set back 224 feet from I-24 or I-25. And then lastly, those commercial lots, Dominion will not be developing those, but we have the same understanding that they will be commercial, and that acreage is not contemplated in our open space calculations. So today I'm here to give a short presentation to talk about our proposed affordable housing community, as well as 2 variances we are requesting that would be needed for this type of housing. So what we have on the screen here is to show the location of the site. This will be focused just on the 17.6 acres highlighted in green. Again, this is a part of a larger parcel. However, the 2 variance requests we'll be seeking today are only for the 17.6 acres. It is located at 4608 State Road 14, south of I-25 and north of State Road 14. The current zoning of the property, I think as mentioned earlier, is employment center within the community college district. That currently allows for the use that we are proposing as well as the density that we are proposing. This site is also designated by the county as a Sustainable Development Area 1, which is to prioritize growth and encourage development in these types of areas. Here we have a preliminary site plan, and we'll have an enlarged site plan at the end so we can take a better look and dig into details further if needed. But this is our multifamily apartment community. This will be family and workforce apartment homes. So 100% of these units will be affordable under the low-income housing tax credit program. So that will be for residents that earn at or below 60% of the area median income. Just to reiterate what Ryan had just mentioned earlier, the 2 variance requests we're seeking today for this community is to allow more than 25% of the building footprint to exceed the 36 feet and to exceed the 36-foot max height to a 38-foot height from finished grade. So just what we're looking for there is to allow our buildings up to 38 feet in height. The second request is to allow more than 12 units per building, and we're currently proposing 24 units per building. So just to shed a little bit more light onto the variances we're requesting to help explain what we're trying to accomplish, looking at our first variance, the building height to allow for 38 feet in height. This is largely due to being an industry standard for this 3-story walk-up kind of garden-style product. This height has been the standard since about the 90s. And in large part, it became a standard just because of the feeling of spaciousness that it gives residents. And that was very appealing to stay competitive in the market at that time, and it's just withstood these last few decades. This height is also needed because we have the mechanical equipment on the roofs. So you can see we have some roof parapets here, and those help to screen that mechanical equipment. We think that's better than having it on the ground because it allows more open space and is just more sightly for residents in the community to see. So ultimately, this additional height would be needed in order to develop this 3-story product. When we start to consider the ceiling height and the truss spaces and the screening, if we're not granted the additional 2 feet over the max, we kind of get pushed into this box of being limited to 2 stories. And what that would do for us is higher construction pricing per unit, because we start to run into issues of we have shorter building, and so lesser units to help cover those costs, such as the roofing structure and the foundation and utility meters. So this variance, paired with our second one that we'll touch on more in a second, if these two variances are not granted, we'd expect a 25% increase in our construction costs. So this was quoted by a GC we work with across the nation. And so in today's dollars, what that's looking like for us is if we are not granted these two variances, we're looking at $300,000 per unit in hard construction costs. But if these two variances are granted together, we'll see that 25% decrease, which would get us to $240,000 per unit. And so those types of cost savings are important for any developer, but especially affordable housing, because we run into the problem that our rents are capped by the Department of Housing. And if we increase our costs, we can't just raise rent to help cover those. So it's that cost inefficiency that would cause that exceptional and undue hardship to the owner if the variance is not granted. The second variance, again, is allowing more than 12 units per building. And again, we are proposing 24 units per building. This is similar in that it's an industry standard, again, for this three-story walk-up garden-style product. You typically see 24 to 36 units per building, but again, we're just proposing the 24 per building. And it also sounds like there is some staff or others that are having a larger discussion about this code, this rule. So it sounds like that could change, and there's some openness to that change. But as we stand today, we still need to seek a variance for it. As I had mentioned earlier, this paired with the previous variance would result in the 25% increase in costs. If not granted, for this variance specifically, if we're limited to smaller or a lower number of units per building, we start to run into those fixed costs being spread over a smaller number of units. So you have costs such as the stairwells, earthwork, utility and cable lines, and some exterior improvements that then are spread over the lesser number of units, which makes our per unit costs more expensive. So similarly, it's those cost inefficiencies that would cause the exceptional and undue hardship to the owner if not granted. You had also mentioned something earlier to staff. If we look at the rendering on the screen, something we've done to help break up the mass of the building is kind of the offsetting and shifting of the facade. We also have stacks of balconies that help break up that facade as well, and it's a different material. And we also have two different color variations throughout the buildings, but they both remain kind of earth-toned. I'll call it Santa Fe style, but it just helps the eye break up the building a little bit better. And this is the last slide I'll end on. This is that enlarged site plan we can take a better look at. Just one thing I would point out quick is if you look at the southwest portion of this site plan, you'll see a blue line here called the proposed extension of trail. Mm-hmm. Part of this development will be extending the trail that goes to the rail runner station. It's just subject to further review with county staff on the exact location of it and what that looks like. But this was just intended to show that we will build this out as a part of the development.
Would that interrupt you for a moment? Are you talking about a walking or biking trail?
Yes, I would assume both, walking and biking. Okay. Yeah. That was all I had, so at this time I stand for any more questions.
Well, I think you heard me say that we had a case like this some months ago, very similar. You're probably aware of that project. It's right near this project. So it was also the very same variances. So some of these issues I've heard, and I don't have any more questions, but thank you for your presentation. Does staff have any questions based on the presentation?
Officer Aber, we have no further comment.
Right, thank you. Well, again, I will issue a recommended decision within 15 business days, and thank you for your attendance.
Perfect, thank you very much.
Hearing Officer Aber, the public hearing portion.
Oh, thank you, every time, every single time. Did anyone want to make a comment on this case? It's attendance? No? Okay. I can't tell. Is there anyone on the web?
Hearing Officer Aber, there seems to be no one on WebEx wishing to speak.
Okay, thank you, Mr. Larrañaga. This time I will call the last case, which is case number 235050, Bernama LLC variance.
Thank you, Madam Hearing Officer Aber. Dominic J. Cisneros, Building and Development Team Leader with Growth Management Division. Bernama LLC applicant, Carl Summer agent, request a variance of SLDC section 7.17.4, no build areas to allow a residence to be constructed on a ridgetop, and a variance of section 7.17.9.2, standards to allow the setback on a ridgetop to be less than 25 feet from the shoulder. The property is within the rural residential zoning district within the New Moon Overlook subdivision and located at 285 New Moon Overlook Road within Section 1 and 36, Township 14 and 15, North, Range 9 East, SDA 2, Commission District 5. The proposed building site is on a ridgetop. The applicant is requesting a variance to allow a 5,726 square foot residence to be constructed on a ridgetop. Section 7.17.9.2 standards restricts constructing a structure on a ridgetop, ridgeline, or shoulder unless there is no other buildable area on the property. There are other buildable areas on this parcel that are developable and would not require the need for a variance request. Per the survey titled Lot Line Adjustment for the owners of the Thornton Ranch that was approved by Santa Fe County building envelope were not designed, developing the lot closer to the road, New Moon Overlook, would be consistent with other residences that were constructed within the subdivision. After staff review, the inspection, it has been determined that the applicant can meet the 25-foot setback from the shoulder as illustrated on the plans provided, therefore will not require a second variance. The applicant proposes to construct a 5,726 square foot residence on a ridgetop. The residence will be a maximum of 14 foot in height as illustrated on the elevations sheet of the plan set, Exhibit 2. The maximum height limit for the structure on a ridgetop, ridgeline, or shoulders is 14 feet for a flat roof or 18 feet for a pitched roof. The property is located within the New Moon Overlook subdivision. The applicant has addressed the variance criteria and staff has responded to the applicant's comments. Building and Development Services staff has reviewed this request for compliance with pertinent SLDC requirements and has found that the facts presented do not support the request for a variance. The use may impact adjacent land uses. No structures may be constructed on a ridgetop, ridgeline, or shoulder unless there is no other buildable area on the property. Staff recommends denial of the variance request to allow the 5,726 square foot residence to be constructed on a ridgetop. If the hearing officer finds that the applicant has met the variance criteria and recommends approval, staff suggests the following conditions be imposed. Madam Hearing Officer Aber, May I enter these conditions into the record?
Sure, yes.
This report and the exhibits listed below are hereby submitted as part of the hearing record. Staff request hearing officer memorialize findings in fact of conclusion of law in a written recommendation order. The Santa Fe County Planning Commission may be holding a public hearing on this matter on September 21st, 2023. Thank you. At this time, I stand for questions.
Thank you, Mr. Cisneros. I have just a couple. On your statement, NBC 4, at the top of that page,
Yes, Madam Hearing Officer.
the first full paragraph, applicant's statement, it says, excuse me, on this 55-acre tract, the covenants only allow for the development in the proposed site. Has the applicant provided these covenants to the staff?
They have not at this time.
Thank you. Are you aware of any other residences that have been built in this particular development?
I am not aware of any at this time.
Did you make a site visit to this property?
No, it was, there was a site inspection by staff, but not myself.
Thank you. Thank you for your presentation.
Yes, ma'am.
And at this time, we'll hear from the applicant, and then I may have some other questions. Thank you.
I will. I would just put all this stuff down and then swear it. I do. Hearing officer, my name is Carl Summer. I'm an attorney here in Santa Fe. My address is Post Office Box 2476, Santa Fe, New Mexico. I'm with Summer Carnes, and I'm here on behalf of the applicant in this case. I have with me tonight Ted Harrison, and he will testify, and I believe there are witness Mr. Mike Krupnick, who is participating on our behalf on the phone. And I have arranged with the information technology to share my screen with you on the site when it's relevant.
Thank you.
Thank you. I've never been in front of you. Nice to meet you. I'm here on behalf of Purnama LLC, which is an LLC that's owned by John and Cynthia Hardy. John and Cynthia bought this property to build their home on back in 2020. I'm here tonight to ask for a variance to the ridgetop requirements of the code, which were adopted under the SLDC in 2016. What I intend to do is to present to you what the central question or request is and why, talk to you a little bit about the New Moon Overlook, which is this lot is within that development, and what is that, and what's a part of that. I want to talk to you a little bit about the history of the Hardys' ownership of this property, what they went through, address the criteria, and then ask Mr. Harrison and Mr. Krupnick to present to you some details about what is proposed. With that, let me turn to what are we requesting. The Hardys bought this property with the intention of building their home on it. They hired architects, they hired lawyers. I wasn't part of the purchase of this property. And they investigated this property, and this property is within the New Moon Overlook, and it has in it designated building sites, the only places one can build according to the covenants. They went through the whole analysis before they purchased the property. They then went through a whole building development process, developed plans, hired a builder, began doing infrastructure on the property, and then they came to apply for a permit, and for the first time they were told that this property is within a ridgetop. The only buildable site under the covenants is within the ridgetops. They did not know that. They were not aware of that. Nobody was aware of it. Staff, the way this arose is that the Hardys, as I went indicated to you, went through this entire process of actually developing plans, hiring a builder, entering into a contract. They actually have part of this house constructed off-site, the bones of this house, because it's a very unique house. And the way this came up was they asked staff to come out to the site. Staff came out to the site, looked at the site, went back and said, I think you can get an extra 10% in height under the SLDC. Well, when staff went back and asked the supervisor, or you're the one that can grant this 10%, the supervisor said, this is in a ridgetop. That is how this all came up. Came up after over a year and a half of their ownership of the property. It is a unique...
Mr. Summer, could I interrupt you just
Sure.
for a second? Prior to the county staff coming out, did the property owners have a building permit?
They did not. Oh, excuse me. They were in the process of, they had applied for a building permit. They did not have a building permit.
But some kind of construction had already started?
I think that they had applied for and obtained a septic tank permit, and they may have applied, I think that's the only permit that they had was a septic tank permit, and that was the permit that they had for the property.
Okay, thank you. Sorry.
Yeah. So they didn't have a permit, they were in the process of it, and they were undertaking it. I'd like to show you, just if I could, where we're talking about. Sorry, Madam Chair. Madam Chair, may I ask your indulgence for a 5-minute break? I can go talk to your IT person.
That would be fine.
Thank you. All right. Thank you very much, Madam Hearing Officer. This property is located in what's called the New Moon Overlook. That property, that vicinity map shows you I-25, 285 that comes down towards Lamy, and the area right there at the curve on 285 is where the Galisteo Basin Preserve is. The New Moon Overlook was an integral part of the creation of that preserve, and Mr. Harrison will go into that in detail, but I wanted to give you an idea where this property is located. And the way it was created was pursuant to this plat, and it was a lot line adjustment plat. Normally, as the hearing officer knows, a development is approved through a subdivision that creates lots and roads and the like. And this lot, this development was created by a lot line adjustment. Mr. Harrison worked for over 20 years to aggregate the entire Thornton Ranch, which was over 10,000 acres of land. And he was able to take the lots that existed there and aggregate them into this development. It is, I think, the largest lot in there. This will take just a second. So the lot is outlined in red on this site plan, an aerial photograph. You can see the shape of the lot. There are two boxes on that. Those two boxes are created by the covenants that apply to this property. The smaller box under the covenants, when this was created in 2005, and is for an equestrian building. The only other approved building site on this lot in 2005 pursuant to this lot line adjustment was the larger box or area to the south on this plat. And if you can see that, there's kind of a little Y at the end of a driveway. That was the plan for this property under the covenants and the lot line adjustment. Unfortunately, the lot line adjustment plat does not include building envelopes or approved building envelopes because the process used was not a subdivision. If it had been a subdivision and not a lot line adjustment, these two boxes would have shown up with the restrictions that we're talking about. This is what the Hardys looked at when they purchased and were told, and they went through a very rigorous process of trying to figure out how to utilize this property. The area that we're talking about that is a ridgetop, the larger box to the south there, is an area that is, I'll show it to you in scale. If you are able to recognize, that is the flatter area on this mesa. It's really a mesa, not a ridgetop. And by that I mean the code defines an area that is longer than 200 feet, on which side, one side is 30 degrees, the other side is 30 degrees. This is not your typical ridgetop in the county's definition. There is 400 feet of flat area across the top where the shoulders drop down, and then in the lower part there is 500 feet. I don't know if you are able to see that, but let me move it. This line right here, that is the top of this mesa on the north side, and this is bottom of this mesa on the south side. And the area where the house was planned is on that location on this mesa. I say mesa because we all usually think of a ridgetop that goes like this and has a crest, a shoulder, and then a top, like a normal foothills or mountain. This is very different than that. And Mr. Harrison will describe how this site was picked in terms of its siting and its impact. So when the parties purchased this property, they went out to the site, and there was story pole right in the middle of this location, and it was represented to them that they would, this was their building site. They were shown the covenants, they were shown the building site, they were shown the building envelopes that are approved, and they purchased it with that in mind, and then proceeded to design this house. As it turns out, this mesa meets the technical definition of a ridgetop because it's got 30% on one side and another 30% on the other side, but the distance between those 30% at the top and the bottom are 400 and 500 feet respectively. Why are we here? Because under the covenants, side of the property, there is what's called a development envelope. Those are what's recorded, and that development envelope is defined there. Is it difficult to read there?
No, it's 1.12, I believe.
Yeah. As you can see, Madam Hearing Officer, it means that the maximum developable area of a parcel, as described in the community development standards, each parcel shall contain one development envelope for residential and equestrian uses and related improvements. So these are the covenants that they bought under. The site plan that I showed you with the two development envelopes, one was for the equestrian and the other was for the house. That's what they purchased. Under the code, this almost 80% of this property is not developable under the ridgetop standards. Let me tell you why I say that. Go back to this area, right? This aerial, only part of this property that would be developable is, you see where my cursor is going, is that area. It is the top, the northern 15 acres of this property is developed. The southern 40 acres is not developable under the ridgetop standards. And in this location, on the 15 acres, under the covenants, no residence is developable. That is an equestrian, that box there shown in the area that is developable is for an equestrian center. So we find ourselves in this bind, and what we're here asking for is a variance to the ridgetop for a couple of reasons. This development was created after 20 years and a Herculean effort to produce 10,000 or more acres of open space. And these sites were chosen because of the minimal impact they have on the siting. It was 10 years after this was approved, the law changed and defined the vast majority of this property as undevelopable. At this point, the hardship created on the property owner is that the vast majority of their property is not developable, and second of all, the part that is developable is not developable for a residence under the covenants because the only residence that is allowed is in the area to the south there. The home that has been proposed meets all other requirements of the code: height, location, terrain management. It doesn't violate any slope requirements. It meets all the setbacks. There is only one requirement under the code that it does not meet, and that is the ridgetop requirements of no build in this location. So the Hardys are not proposing and do not want to build something that otherwise, except for this one regulation, would not be developable. I have with me here today, I think Mr. Krupnik is on the phone. Is that correct, if we can check? Mr. Krupnik is the architect who has been helping the Hardys hone this development so that there are no other requirements that cannot be met by what they propose on this property. Is Mr. Krupnik on the phone? Is there a way to tell?
I'm sorry, Carl, what was the gentleman's name?
Krupnik.
So we have 2 call-in users. I don't know if it's gonna let me unmute it.
If they are on the phone, you can do *6 to unmute.
His number is a 505-819, I believe.
Well, if he's unmuted, he can speak. I can't unmute him. Needs to, gentlemen, sir, you need to unmute if you're on the phone, so you could speak. I have 2 callers on the phone, but
If you are on the phone, you can press *6 to unmute yourself.
Madam Hearing Officer, what we could do is move on to Mr. Harrison, and I'll
That would be fine.
I'll
Let's do that.
communicate with Mr. Krupnik.
That would be fine.
I do. My name is Ted Harrison. I'm the president and founder of Commonweal Conservancy, which is the nonprofit organization that conceived and developed both the Newman Overlook and 3 other neighborhoods that are part of a larger conservation initiative that we call the Galisteo Basin Preserve. My address, sorry, I neglected that, 314 South Guadalupe, Santa Fe, 87501. In 2003, when Commonweal began its work, Santa Fe County's zoning and development guidelines were an aggregation of policies and ordinances that seemed to be primarily focused on water availability. That seemed to be the principal concern as to how development could occur, especially in the outlying areas of Santa Fe County. This property is located just south of El Dorado. To give you a little additional context, approximately 3 miles south of El Dorado. When we took on the opportunity / responsibility challenge of trying to protect this legacy ranch, which we felt was at risk of being carved up into 12.5 acre, 40 acre, and 160 acre lots with roads that would have been going in all different directions, fragmenting habitat, compromising view sheds, and providing no public access or recreation value. We felt that a continuation of El Dorado, as much as that is a beloved community and well-planned at its time, that there were better models of how we might pursue development. And so with staff that had come from the Trust for Public Land, which is a national land conservation organization, and myself and board members, all of whom were associated with the Trust for Public Land, we undertook a model of what we called conservation-based community development. And the idea is that we would look at this property as a case study in how we might identify areas of this 10,000 acre property that could be appropriately developed with minimal impact to public values and natural resources, and then use the monies from the sale of the private home sites to fund the acquisition and infrastructure development for what was originally conceived of as an eco-village that was proposed to be developed in the basin just to the, from my vantage point, to the right and south. You see where the escarpment edge is, and then below that you can see an arroyo that's coming through that area. That was the subject of many years and millions of dollars of our own planning and development work to bring forward an eco-village, which ultimately the 2008 recession made impossible. But before that, more difficult part of our story, we did go forward with a few prototypical neighborhood development projects, and the Newman Overlook, which was actually the second. We pursued a very small, what we called conservation homestead development project just west of County Road 42. And that was comprised of lots in the scale of 160 to 220 acres and was very well received. So our first pass at a development plan that would generate capital to then move forward with securing loans and buying property from the legacy ranch family, the Thornton family, was so encouraging that we then moved forward with an acquisition of an area that was about, I believe, 1,600 acres. That included this area that then became the Newman Overlook boundary line subdivision, boundary line plat. I can't tell you how many hours my colleagues and I spent on the ground on this property trying to identify appropriate sites that a home and equestrian facilities might be appropriately developed. But it was exhaustive. I think we spent 8 months literally on the ground and then working with consultants that included GIS professionals, land planning professionals, attorneys, and the like, to both conceive a land plan, which we felt would both give value to the purchasers of these lots in terms of views, privacy, and control in terms of what would be happening next door on the lots that they were adjoining, to ensure that the experience that they would enjoy as lot owners would be unique, protected, and also not compromising of the adjoining open space, viewshed, habitat, cultural resource, and water resource values of this property. So when we brought forward the plat, or rather, the boundary line adjustment in 2005, it went through a very simple process. I mean, at that time, there was a staff member who would review the plan from the surveyor, and if it met minimal lot sizes, and if there was a reasonable access plan, then it was approved. It was quite routine. We did not, as Carl mentioned, apply development envelopes to that plat because it wasn't required. We did it subsequently. In retrospect, obviously, that was a mistake. We wouldn't be here today if we had brought that additional piece of our planning work to bear on the plat. The surveyor didn't expect it for boundary line adjustment, and we didn't know enough, honestly, to include it. Hindsight brings us here today to sort out then whether, in fact, we can go forward, and this property owner in particular can go forward with their original dream of a home site on lot 15 in the area that we had planned. I think, Carl, you can move to the next slide. And
well, before we move, could I just ask you a question?
I'm sorry, sure.
How far is this lot 15 approximately to the west of, is this 285 that over here on the very edge?
So 285, yes, 285 is on the right-hand side. You can just see it curving out of, it has a little arc on the edge of the map.
Approximately
Right
how
there.
far is that from this lot 15?
That is approximately 2 miles, 2.5 miles. Oh, I'm sorry, no, from lot 15, 3.5 miles is the distance. It's quite significant.
And also, of all these development, of all these lots, do you have any sense of how many actually have residents on them at this time?
I think there are 8 structures in the 20 lot subdivision or community at present. And then there's 2 more homes that are also in design and on their way to submittal for development approval. And those lots include Lot 2, Lot 4, Lot 9, Lot 20, Lot 18, Lot Lot 14, actually. And Lot 6 as well, to the north of the Newman Overlook Road.
Well, you seem to know this pretty well. To your knowledge, have any of those other lots had to request variances?
They've not. They've not. And as Carl mentioned, this property is unique because whether it's described as a mesa or a peninsula, it wasn't, in our mind, conforming to the definition of ridgeline per se. The ridgeline, the prominent ridgeline, was that edge of the escarpment that's really front and center to this map. And that ridgeline provides both a really beautiful and important edge from the travelway of US 285 as you're coming down the hill from El Dorado towards Lamy and then eventually towards the turnoff to Galisteo. That ridgeline essentially blocks your view into the home sites that are situated behind it. And the only view for Lot 15 that impacts a travelway is County Road 41. It's not visible from County Road 42.
And it's not on this particular screen, County Road 42?
It's not.
Okay.
I can share with you
No, that's fine, that's fine. Let me ask you, would it be possible to put this home where what has been designated as the equestrian area?
Theoretically, but the original plan and the covenants provided that there were very distinct envelopes for very distinct uses. I also just want to mention that the building envelope, as you can see generally from this map, and you could see from the earlier drawings that Carl showed, is set back from the, quote, ridgeline or the edge of this peninsula about 50% north of where the actual southern boundary of the mesa/peninsula ends. We were very deliberate about that location, and I think the siting of the home sets the center of the home even in the top half of that building envelope to ensure that the view shed, which if I could present hearing officer and staff with a set of maps that show the visibility analysis that we did, if that would be helpful. We tried to include it in the presentation, but I think my submission to Carl was a little bit late in coming. Would it be helpful for both of you to have a copy of this right now? And I've got 3 copies of it. And the map that we're looking at are 2 additional maps that show how this parcel in particular matches up with views from both the interior of the property where the open space and recreation is centered, and then also from the roadways. And this anticipates a structure 15 feet in height rather than the restriction and height limit that architect Krupnik has put forward.
Well, it may be the architect that could answer this question, but I'm going to ask you because we may not get him.
Sure.
Do you see any issues of the proposed siding creating any kind of a drainage issue, erosion issue? It does look fairly close to what seems to be sort of a drop-off there on the east side. Is that any kind of a concern? And again, this may be something for Mr. Krupnik.
I think the engineers have probably done a very thorough analysis, and I don't think that was a concern of the county, actually. So any kind of stormwater flows around or through the home would need to be managed through the separate regulations of stormwater management. You want to jump in?
Madam Hearing Officer, it complies with the terrain management requirements to pond. There is no runoff that will leave this site. It'll have to be ponded on site. So that it's set back from the shoulder so that there's not water running off the site. And any impervious surface that generates runoff has to be retained pursuant to the code, and this complies to that. This would comply with that. And the plans that were produced showed that compliance.
Thank you.
Without belaboring my part of the presentation, I guess I just want to jump to, and these maps that I've just shared with you and staff help illustrate this, that I believe the primary concern and purpose of the Ridgeline Ordinance, or a section of the code dealing with ridgeline development, deals with erosion, impacts on erosion, and then very substantially impacts on viewshed, the experience of adjoining property owners or people that are traveling along roadways that would be looking at, in this case, the elevated areas of the property and seeing a structure that would disrupt or compromise their experience of the Galisteo Basin in this case. We were extremely attentive to protecting against that sort of impact. And that's why, again, we set the building envelope back from the southern edge of the mesa. We limited the size of home that could be developed, and also required that, of course, any development be in conformance with county regulations with regard to stormwater and the like. As the major landowner that surrounds this property, the entity that would be perhaps most impacted by the viewshed impact of this home, we are completely supportive of the home in its design, in its location, relative to the thousands of acres of open space that we own and wrap around this property.
And that's the Conservancy,
The Conservancy absolutely is completely supportive of this home site as the major landowner that potentially could be the most impacted by an inappropriately sited home. I also want to just point out that if you take stock of the surrounding ridge lines from 285 and look north, you will see an assortment of homes right along the ridge line that come up against our property and are often confused as part of the preserve, and we're quick to point them out as examples of what we were really trying to protect against. And whether that's close in on the Lamy Ridge Road or Lamy Crest Road, or the roads that extend on Ranch Road out to the different ridge lines above Lamy. We feel our project, and this development in particular, exemplifies all of the values that have been subsequently incorporated in the SLDC in terms of conservation purposes of viewshed, habitat protection, open space creation, watershed protection, and cultural resource protection. And we were deliberate about citing the home parcel, the home envelope on this property, because we knew that set inside, closer to the loop that wraps around the other home sites, it would have been of marginal value and interest. There would have been little opportunity to have much benefit economically to then support the larger open space and land acquisition purposes of the larger project. We saw this as, the most prominent, most valuable offering of the Newman Overlook. And because of the way we were approaching its planning and siting, felt like we were able to be both respectful of all the public values while also being able to capture some additional economic benefit by the location of the home site in this place on the mesa.
I'd like to point out that it was not the Conservancy that sold the property to the Hardys.
True.
So he's not here under any
Duress
compunction.
or-
Right,
yes.
he's got no interest in this. He's here on our behalf to talk about what happened. I didn't want to leave you with any misimpression that he had anything to do with the transaction. He helped, approve. I think they go through a process of approval for this site, but that's through the homeowners.
That's right.
Through that. So I didn't want to leave you the impression that, oh, well, he sold the lot, so he's here testifying on their behalf. That's not the case at all.
No, thank you.
Any other questions, Madam Hearing Officer?
Mr. Harrison, I don't have any other questions, but staff may. Mr. Cisneros or Ms. Larrañaga, do you have any questions for Mr. Harrison?
Hearing Officer John Lovato, Building Development Services Supervisor. So I did the initial inspection on this property, and when I initially approached the site, I thought no problem because I believed they were going to develop within the entrance there where it's more flat and closer to the road. But as I got to the site, I noticed that it was under our terms in the SLDC as noted as a ridgetop. And what a ridgetop is defined in our ordinance is when you have a 30% slope on either side and then you have the crest. Santa Fe County does not allow under Chapter 717 of the SLDC ridgetop development unless there is no other buildable area. In this case, I noted there was other buildable area that was closer to the road. Now, what was presented to you tonight was covenants and not code about ridgetop development, which I respect covenants, but are not enforceable by Santa Fe County.
Yes.
What I have to go by is off ordinance. And the ordinance clearly states that no development shall be allowed on a ridgetop unless there is no other developable area. Now, as Mr. Summer pointed out, there is a provision in the code that talks about the 500-foot where a ridgetop measured from side to side or whatever it be, where you hit 30% slope. Now, what that allows for is because there's no allowed buildable on a ridgetop, oftentimes we do get ridgetops that need to be developed, and they may need to meet setback of 25 feet or 100 if they're above 7,400-foot elevation. In this case, what kind of alludes to the fact of this particular property is there's buildable area elsewhere. Now, had this 500-foot from shoulder to shoulder and was the only developable area, and they wanted to go above the 14-foot elevation height, and the architectural appearance style and standards apply. And that allows for 23 feet, 22 feet, and they don't have to abide by the 14-foot, 18-foot pitched rule. Now, because we have the ridgetop of the crest and the crest, that kicks them into the standards of ridgetop development, and this is not allowed on that ridgetop. I just wanted to point that out. There's different ways of interpreting it. We pretty consistently handled this in the same fashion. And as noted by Mr. Harris, there are homes that are there that are close probably to the 30% slope. Those are pre-code homes or pre-ordinance 2016-9 homes that are on there. Now, that might be the possibility of why those are there and the way they are, because we did not have those restrictive setbacks, although we did not allow development on ridgetops. However, we did not have the vast or the definitions that are in our ordinance to decipher that at that time. So I just wanted to make that kind of clarified, and I'll stand for any questions if you have any on those.
Mr. Lovato, you said that you believe that there are some homes in this particular development that predate the code, the current code, 2016 code?
As I'm aware, most of those homes are pre-code of 2016. There may be some that were permitted, and they may meet the setback. I'm not sure. I'd have to do a little more investigation on that, but a little more research. But as far as I am aware of.
Okay, thank you very much. Mr. Summer.
Madam Hearing Officer, I'd like to point out that there are at least 2 homes that are post-2016 that were permitted in this development. And the reason I haven't talked about that is, as you know, if they issued permits to somebody that didn't meet the requirement, that is not a precedent that I could stand up and say, well, they did it there. I'm aware of at least 2 homes that were built in locations that would have required a variance. It's not relevant to my case because if it was allowed for whatever reason, they're there, and one act by the county is not binding on us. So I haven't brought that up, and I think that I'd like to just conclude, if Mr. Krupnick is not available, doesn't sound like he is, by talking about the criteria, I think that Mr. Harrison has indicated to you what one of the criteria is: the public interest. Is this in violation of the public interest? This whole development and this whole concept arose out of a desire to preserve a 10,000-acre ranch for the most part. And the only way to do that was to create large tracts of open space, but be able to do something that generates the funds necessary to acquire and actually make the preservation a reality. This lot line adjustment, the New Moon development, was integral to that. Its siting was for this particular lot was done in the context of conservation, preservation, minimization of development on impact, while still being able to generate this much larger objective, which has been a worldwide, a world-famed success. And I think that probably everybody in this room has been to the Galisteo Preserve and maybe rode their bikes out there or hiked, but it's only possible because of this. My clients purchased in this development and are part of these rules that came into place. They didn't know about the ridgetop ordinance, and I think what happened here was, in 2005 there was no ridgetop ordinance. The ridgetop ordinance was developed, and the provision was developed in 2016, and it completely doesn't deal with a situation like this. And I submit to you, there is no other situation like this. If this had development envelopes on it, if it had building envelopes on it, staff will tell you that those would have been grandfathered in under the code. The fact that it did not have building envelopes was the result of it being a lot line adjustment plat, not a subdivision plat. It was a lot created nonetheless. I submit to you that this is in keeping with the public interest because it is an integral part of what has allowed, what has been created by Mr. Harrison almost single-handedly, and the Nature Conservancy.
Mr. Summer, do you have that part of the covenants that you had on the screen? Do you have that in a hard copy?
I can get that printed for you. I can print the
Because
full
didn't
set.
that refer to developable areas? It may not have said.
It refers to a development envelope, and the development envelope that I showed you on that aerial photo was a development envelope for this property.
And how does that differ from having had that designated otherwise? It seems to me that would be the same thing.
I'll tell you why that does not show up on the plat. The plat itself.
Oh, I see.
You see,
I see.
If I go to the county record and I look at the plat, I see this lot. And the reason it doesn't show up on that plat is because it was a lot line adjustment and not a subdivision plat.
Yes, and I would like for you to supplement the record with that hard copy of that.
I will.
Thank
I'll
you.
provide that for you immediately after this hearing. The other is the exceptional circumstances and the situation here. I'm not going to go through all of it, but this is a unique situation. I submit to you, there's no other property in the county that is similarly situated with respect to the circumstances that give rise to this request. This whole development and the acquisition of it are exceptional in this situation. The last question that you have to look at is the spirit of the SLDC and substantial justice. I think that the spirit of the SLDC is to minimize development impacts on ridgetops. That's the obvious purpose of a ridgetop ordinance, is so that people aren't, from the public, looking at a piece of property and seeing these houses across the tops of ridges. In this particular instance, this house will not be seen from 285, and I submit to you that it probably is not going to be seen from 42. 42 is a good distance away, and this is a single-story, 18-foot house that sits in the center of what is really a mesa top as defined by the code. So is it in keeping with the spirit of the SLDC? I submit to you it is. And finally, we believe that it would be just to allow the Hardys to be able to use this property in the way that it was created and the purpose for it. There are other properties in this development that are going to utilize their properties in a similar fashion. And I think that we would stand for any questions, and I really appreciate your time.
Thank you, Mr. Summer. Was staff have any questions for Mr. Summer at this point?
Hearing Officer Aber, staff does not. Thank you.
And now I'll ask if there's anyone that would like to speak from the public on this matter. And I don't know, is there anyone on the...
Officer Aber, there are 2 phone-ins, but they haven't. I believe it's *6 to unmute. They'd like to speak.
So what do we do? I have nothing to do with that. Matt, do we need Matt? Matt? Can they hear you? Yes. Okay.
So hearing Officer Aber, apparently they don't want to speak because they're not unmuting their phone.
They're not responding. Okay.
Yes.
All right. Well, with that, this case will be concluded, and I will issue a written recommendation within 15 business days. Thank you all for attending.